Codification. It might be useful to say a few words on codification in the history of the law in Europe, and then to discuss the place of codification in French law today. I need not say how important was the place of codification in the history of European law. The best examples being, of course, Roman law. I need not comment on the work of Theodose and Justinian and the Corpus Juris Civilis. And the other codification is, of course, that of the Roman Catholic Church. The Code of Canon Law, which was enacted for the first time in 1917, was preceded by the drafting of the Corpus Juris Canonici, starting in the 12th century. So codification has a very old and respectable history in European law. And one could say that both codes, both codifications, were already very good examples of the first wave of Europeanization of the law. What is the place of codification in French law? I think that several misunderstandings should be dispelled. First one is that Napoleon was the first to enact codes in France. This is not so. During the 17th century, under the monarchy, a number of codes were promulgated on civil procedure, on criminal procedures, procedure on trade, on the navy, and on slavery. The famous Code Noir, the Black Codes, enacted in 1685, describe vividly the rights of the matter of the slaves, and buying, selling, punishing. Exactly. It had no. It could be used. It could be compared to the law in force then on the other side of the seas in the south of the United States. If we come to the Napoleonic codifications, to be true and to be fair, the codification, the main codification, that is the Civil Code, did not begin with Napoleon. It began 10 years earlier, in 1784, in the middle of the Civil War and the French Revolution. When civil peace was restored, when there was more political stability, then Napoleon was able to go ahead and finish it. And the scope of what was achieved is extraordinary. In 7 years, 5 codes were enacted: the Civil Code, the Code of Civil Procedure, the Code of Commerce, the Criminal Code, and the Code of Criminal Procedure. All these between 1804 and 1811. The influence of these codes has been immense, both in France and abroad, in many European countries, in Holland, Belgium, Portugal, Spain, South America. They have been very influential not only in the formulation of the law, but in the way law was taught, the way courts wrote their judgment. We are back to your question. And it created a legal culture of its own, to use the notion of legal culture. Now, I spoke of misunderstandings. Very often, speaking with English or US lawyers, one sees what could be called, in all fairness, misunderstandings. One of them is that the law in force today is still that contained in the 5 codes enacted under Napoleon. Nothing could be, of course, more wrong. All codes have been deeply revised and changed and modified, and some of them have been totally rewritten. This is so for the Criminal Code, the Code of Criminal Procedure, and the Code of Civil Procedure, and the Code of Commerce. The second opinion is that the only codes in force now in this country are the 5 Napoleonic ones. This is not so. A number of codes have been enacted during the 20th century: taxes, agriculture, labor, administrative justice, housing and construction, family, elections, local administration, driving, urban planning, insurance, social security, education, etc., etc. Many areas of French public social life are, the law applying to them is codified. Another error often met is that many people believe that since France is supposedly the birthplace of codification, even administrative law is codified today, as civil law is. It is not. Basically, administrative law has been the creation of the case law of the Conseil d'État since 1 century. It still is a judge-made law, although the place of statutes, of regulations, and of treaties is much important, more important now than it was earlier. What we have now is a code of the procedure before administrative court, Code de justice administrative, Code of administrative justice. But we have no code of administrative procedure. We have a number of basic statutes and regulations regulating it. I think we should have one, because the case law has been there for a number of years, and it could be easily summed up and codified and clarified, in my view. What is taking place today, this is the last element, is a new form of codification. When Napoleon undertook its codification, it was a very ambitious work. It took the law of the Ancien Régime, case law, customs, written law, regulations, statutes, and summed them up in writing and rewrote them, created a new law. Not totally new. Nothing is totally new in the history of law, but it was a creation. Codification, as is performed now in France, will be more properly called compilation. That is, when you take a matter, the law of education, a special commission is in charge of codification. Once it decides to enact, to prepare a code on education, then experts from the ministries and other people will be called. They will assemble all pieces of legislation relating to the topic, then we'll arrange them in a logical and clear order. Nothing will be changed in the wording, in the writing, except if one finds something which is clearly contrary to the Constitution, or which is in breach of treaties. Otherwise, even if it is badly written or if it has become obsolete, it is compiled, it is there. A number of codes have been enacted, and I think it is a good thing, because it makes the law more accessible, clearer, for practitioners, for students, for professors, for administrators, for all who have to use it. Access to the law is, and then the very intelligibility of the law are basic in a democratic society if we want people to be aware of their rights and obligations and to behave according to that. The case law of the Conseil constitutionnel, the dictum of 1999, says explicitly that the accessibility and intelligibility of the law is an objective of the Constitution. Why so? The Conseil explains. Without it, many principles contained in the Constitution would not be effective. Equality before the law, the guarantee of rights, the very exercise of fundamental rights, etc., etc. It is true that if one remembers the situation before such codes existed, when you were writing something on education law, you had to you had to know which were the main statutes, some of them dating from the 19th century. You had to look at their successive revisions. You had, unless you were a very expert lawyer, you had to spend hours or days in libraries to assemble the text, and always fearing to make a mistake or to omit someone. So these compilations are extremely useful instruments for all kinds of people, again, and all those who use the law and must know it. There are limits to the exercise. Again, this is not a creation, it is a rearrangement. It can be, it is different from the restatements in US law. What the American Law Institute does could be called kind of private codification. It has no official value, but in fact, unless I'm wrong, it is extremely influential because it is done by expert lawyers coming from all shades of opinion, law professors, lawyers, administrators, etc., etc. It is quoted by the courts and by parties in litigation, and it is very influential. Although technically speaking, of course, it is a private work of an association. We do not have in this country or in Europe in general such kind of private codification. Many things are missing in today's compilations. European law is not there. Now, as I will explain later on, many areas of French law are governed by, in a growing proportion by EC law. So you have to go and look at the corresponding directives or regulations, which are not codified even at the Brussels level. There is no code of EC law. Maybe several rooms would not be enough to contain. What the Commission is trying to do, from what I read recently, is when you have one directive or one regulation which has been revised 5 or 10 times, there's not even a consolidated version of this text today of official value. You have to go after the initial one, then the first revision, second revision, and then use your time and patience. Certainly, I mean, if we go at the European level, if there was some codification of EC law, it would help a lot. But to this day, the Commission has not been able to launch this. What is also missing in today's compilations are the rules enacted by independent authorities in broadcasting, stock exchange, railways, utilities, etc. And since this is also a very important part of the law, it is to be regretted that these rules are not to be found in the present day's compilations. One could say that today's compilations are still prisoners of the old system in which the only majestic source of the law was the statute, la loi, enacted by Parliament. Now we have at the international level treaties bi or multilateral, plus EC law, which is sui generis, of its own kind, and besides statutes, regulations, rules enacted by independent authorities. And clearly, any businessman or any practitioner who wants to have the whole law relating to one area cannot be satisfied by one of these. He or she will have to have recourse to other compilations. But maybe this is an impossible objective. But it is a fact.